We'll go ahead and get started. Tripp Watson with the Watson firm. Today we're going to be talking a little bit about incorporations. Now, as you can see, there's plenty of them that are available. So in order to kind of parse this out, I'm going to approach this with the concept that we're going to look at this historically, how they all developed, where we got to where we are, and try to figure out what's the best for your existing business. As you can see, all of these are listed up here. Not all of these are available in the state of Alabama. A limited liability partnership and a professional limited liability company and a series limited liability company are not available in the state of Alabama. So if you want to set those up, you've got to go outside of the state. But hopefully we'll be able to explain a little bit about the other ones so that we can understand where we are. So let's go back to the time of the dinosaurs, which in legal circles is ancient Rome. So the very first thing that you ever had was a sole proprietorship and a general partnership. Sole proprietorship is basically what happens when nothing happens. If you could start conducting business and you are a sole proprietorship, that means you are the business is not separated, you've not taken any steps to protect it. So the court says, okay, your business and you are the same person. That's what a sole proprietorship is. And that's the one that first started out. Going along with that is a general partnership. You go to somebody else, and these are literally the simplest forms of possible. Handshake agreement. Hey, you want to do business? Sure. Then you start selling stuff. That's a general partnership. So this has been recognized for as long as we've had a law. And so this really starts where we are at the base of our little tree that we're going to map out here. So, back in ancient Rome, when they originally started these concepts up, there was not the idea of a limited liability entity at all. If you conducted business no matter what, you were on the hooks for everything. So if you ended up doing fantastically well, you got to see all the profits, you didn't necessarily have to do any of the administration or necessary in order to maintain a corporate entity. But at the same time, if you screwed up, business didn't turn out the way that you wanted, they could come after your personal assets. So this obviously was not a great situation. So later on, about 500 BC, we started seeing the development of traditional corporations. Now, corporations start going on this line that we'll show here. This is corpse. So they developed the concept that it doesn't really encourage businesses to do business with one another, especially for one person to partner up with somebody else. Because if they're going to be on the hook for everything, then we need to figure out some kind of way to limit their liability. So that's where the corporation originally started up. And we see it's still existing very much in the same way that we see it today. The whole concept is you do a little bit of extra work in order to set up a separate entity, and then that entity exists in a fictional state that can be sued. But at the end of the day, you can't go after the person originally who set it up to get their assets. Now, I know ancient Rome has very, very few parallels to where we are now. It's a very different legal system, but it's a good starting point to where we come from. Because as we fast forward, all of these start developing in about the mid-1700s. We start seeing the very first limited partnerships. Now, the reason that a limited partnership is different than a general partnership is that some of the members in the limited partnership don't have unlimited liability. Now, a basic tenet of a general partnership, the old general partnership, is that any partner is not just liable for what they do in the business, but they're also liable for their partner. So if you end up going into business with an idiot and they end up racking up hundreds of thousands of dollars of debt, then that business that they've racked up hundreds of thousands of dollars of debt to could potentially come after you personally after your buddy has skipped town. So this was obviously not very conducive to get people to do business together, so there started becoming the concept of a limited partnership. Now this is where we started seeing this split here. Now, to understand a general partnership, like I said, the idea is that as a matter of public policy, they didn't want somebody to just be able to get away with anything. they wanted at least some recourse. So if you didn't make good on your promises, then something was going to happen to somebody, that there was some recoverable method. And this started back in England, back in the 1700s. The concept of a limited partnership is that some partners were not going to be liable for more than what they had contributed into the partnership in the first place. Pretty simple concept. However, there was going to be one general partner, one guy who had to take the fall if everybody else messed up. And that was the dangerous part of any kind of partnership. So, on the other hand, there was the corporations. You had the partnerships, you had a corporation. Corporation, you had to do a lot more legwork to get it set up. But if you did the legwork and made sure that it was protected, you got unlimited liability. The problem is that because it was a fictional person, it got treated like a fictional person. It was taxed, it was regulated, it had to have a lot of the same attributes as an individual because it was a legal individual. That was the idea behind a corporation. One of the cool things that I think about corporations is that they were originally started up in Italy, because the modern corporation that we recognize them now, several business owners, when they wanted to ship things across the sea, didn't necessarily want, if in a highly risky endeavor like putting a ship out to ocean, they didn't want for the ship to sink and then all the other parties say, this is your fault, we're going to figure out a way to get our money back. So they would form these limited corporations just for these one-off tasks. The problem is that they didn't really exist in perpetuity. Actually, the church brought that out. Church started using when they originally set up corporations, they were supposed to exist for a finite period of time, and the church realized, hey, we can set up these business corporations, these entities, and the church will exist no matter who's a pastor, no matter who's there. And so we started developing another theme of these entities, is that they outlive the people that make them. So, I know that we're quickly going through the history, but now we're starting to get into the relevant period. At about the late 1800s and the early 1900s, we had basically two theories of how corporate entities existing in the United States. We had corporate entities and we had partnerships. Now, partnerships, like I mentioned, could be general or limited, but at the end of the day, in a partnership, one guy was going to take the fall for everybody else. In a corporation, you had to do a lot of legwork, and it was treated as a separate entity. This further got complicated with the income tax. When the IRS came around, they decided to throw everything into a kink, and because a corporation was going to be treated as a separate entity, it got taxed as a separate entity. This pushed a lot of folks into a limited partnership or a general partnership situation because of the ease of use. The problem, obviously, was that somebody inevitably was going to take the hit. Somebody, the general partner, was going to be responsible. Now, lawyers are smart. We figured out ways around it. What we ended up doing was we made the general partner a corporation. The corporation never received any assets, but if the worst case scenario happened, their recovery method was against a limited liability entity. So, fun little ways that lawyers throw kinks in otherwise good ideas. But that kind of tells you where we are. So as of about the 1930s, the income tax is really starting to be rolled out in a big way. We start seeing that there now becomes not just a legal reason, but a corporate, a taxation reason to form a particular entity. Because now many companies are being discouraged from filing a corporate entity because of the taxation schemes. So they're looking towards being a partnership because now you don't have that double layer of taxation. You have a single layer because the partnership is removed. So anyway, as we're looking down this continuum of what gets set up, we see that we've already developed a sole proprietorship. We see that we've developed a general partnership. We see that we've started developing limited partnerships, corporations, but a lot of other this gets left on the table because none of this really showed up until the income taxes started getting really high in about the 50s and 60s. So people started looking for other ways to kind of game the system. Now, as I mentioned, not all of these are available in the state of Alabama. So we'll start tracing how they ended up getting set up. The very first thing that you started seeing were limited liability partnerships. Several states started allowing an opt-in, or you could start as a limited liability partnership from the very get-go. This removed that general unlimited partner. So now you had a partnership that got taxed as a partnership, but you didn't have to necessarily have somebody that was going to take the fall if the business went under. But it's not really the best scheme because it's still a partnership. And then for one of the reasons later, I'll tell you why that's one of the problems that it has. So you started seeing this limited partnership model go back towards here with an LP and then back further with an LLP. But like I said, not many states adopted it. So on your continuum, you have awesome taxes, both of them have limited liability, but you had awesome taxes and corporate regulation, but you got a little bit more protection. So you started seeing some of these partnerships develop string-offs that had the ability to offer a little bit more protection with some of the same taxation schemes. Now we start talking about corporations. We've kind of not talked about where they were. Corporate entities over time had started being subjected to a new science, a science that we called business studies. We started realizing that businesses did better under certain circumstances. As well, we also found that businesses did pretty poorly if they had different management structures. So we started realizing that it was pretty good for businesses to have an advisory panel. We also recognized that it wasn't always the best case scenario for the people that owned the business to be actively managing it. It created a conflict of interest sometimes. We also recognized that it wasn't necessarily best for all the owners to be able to hire and fire somebody. There needed to be an intermediary, somebody that was more involved in the business than, say, a passive investor. Because in the 1930s and 1940s, we started seeing people put money into stocks, the increase in the publicly traded companies. So we started increasing the requirements on existing corporations. They had to have a board of directors. They had to have separate shareholders from officers. And even though one person may be a shareholder, may be on the board of directors, and may also be a officer of the company, there was no guarantee that any one action that he did wouldn't get him in trouble, because he might be violating some duty or this, that, and another. So we started recognizing that the traditional corporation is not great for single member or single owner companies. So how do we fix that? So in the 1970s, we came up with the concept, or Wyoming did, of the limited liability company. This was ported over from Germany, who had started doing this. They have an entity that I cannot pronounce, and I won't, that was kind of the same concept. We're going to take away a lot of the requirements, some of what used to be good business practices, but we're going to make it a little bit easier to just manage the business, especially if there's a single owner. And so Wyoming ported this over in 1977. In between 1977 and 1996, almost every single state adopted an LLC rule. The benefit of an LLC is you get the benefit of the protection of a corporate entity with some of the tax benefits that you get of a partnership, but you don't necessarily have to do the legwork that you typically have to do with a traditional corporation. You get the opportunity to set it up. By Alabama law, it's basically a one-pager to get set up in the state of Alabama. And so the requirements are pretty minimal. That also creates its own problems, which I'll talk about in just a second. So when we start looking at the development here, we can start seeing where some of these concepts come from. Is we have the traditional corporation, but we wanted to have more partnership capabilities. And we had partnerships, but we wanted to have more of the corporate protections. And so this is where we are today. And on this list of options are what is available in the United States today. So, what is a business, now knowing where we've come from and everything, what's the best scenario for a business? Now, very first and foremost, a sole proprietorship and a general partnership, that is 95% of the businesses in the United States. And it is the worst. possible business entity that you can possibly imagine. How do you set one up? You don't do anything. It's the default rule. So in the United States, if you don't do anything, you are a sole proprietorship, or if you are with a partner, you are a general partner. What does that mean? Your business does really, really well. You get the benefit of the business and the profits. You get the recognition. It's all you. But if the business goes bad, that's your 401k. That's your college fund. That's the nice shiny new car that you have in the front of the house. It's your house itself. Not a great scenario. So, most businesses get tracked into either a limited partnership, a corporation, or a limited liability company. Those are the three main options that are out there that are often tossed out. The reason that a lot of these others, the limited liability partnership is not typically available in a lot of states. The professional corporation is only provided in a few industries. The professional limited liability company, the same situation. Business trust is complicated. And a series limited liability company is only available in about 5 states. So you had a very limited option as far as what your corporate options are. So we have basically 3. Your limited partnership, your LLC, your traditional corporation, and an LLC. So what are the benefits of each? A limited partnership, like we talked about on this scale, is basically disregarded by the IRS. The IRS has said this is not a separate entity. There's no reason for us to treat it as a separate entity. So anything that the partnership makes passes pretty instantaneously on to the people that are in the partnership, which is great. Like we had talked about before, you get the upsides of your business. If it does incredibly well, you get the potential profits. As well, you don't get a double layer of taxation, so you're only going to be taxed on income, which is pretty great. Now, I will put a disclaimer in here. I know enough tax to make myself dangerous, but I am not a tax lawyer. Mm-hmm. So whenever I recommend folks set up these types of businesses, I always recommend speak with a CPA, because there's specifics that change every single situation. So even though a partnership might sound great, there might be another taxation scheme that's more interesting. So with that disclaimer, the other option that a company has is a corporation. Now, the reason that corporations are fantastic is if you have multiple owners and you're going to be doing business in multiple jurisdictions, especially if you have ownership in multiple jurisdictions. The corporate formalities that are often required of a corporation are best business practices. The reason that they were implemented in the law in the first place back in the 1800s and the late 1800s and early 1900s was because there were good business concepts. A lot of the leading thinkers in the business community advocated for this and pushed for the laws to be passed. So they come from a good place. The problem is that they break down on the smaller scales. This closely held companies is what we call them. So if you're on a closely held company standard, it's typically pretty difficult to maintain the corporate compliance. Because if you don't do what's necessary for a corporation to be maintained, there's a legal concept called piercing. Now, piercing, or piercing the corporate veil, means that an individual can bypass, or not even bypass, but can go straight through a corporation, invalidate it, and go after those college funds that we talked about beforehand. So, typically for closely held companies that don't have the ability to maintain corporate formalities, to do a bunch of the things that are necessary in order to maintain their corporate existence, the best opportunity is typically the LLC. Now, in my business, I recommend typically 90% of businesses an LLC. That's for 2 reasons. One, it's the easiest and it's the cheapest. Secondly, it is flexible. The benefit of an LLC is its flexibility. There are no requirements, but there are options. You can issue stock. There can be multiple layers of stock. You can set up different classes, different benefits. You can set up different things internally. The only thing it's going to mess with, it's not your legal obligations, but your tax scheme, which is pretty fantastic in an LLC. You get the benefit of saying, we're going to have a preferred share partner in our business, but we don't necessarily want to file a traditional corporation because of the maintenance of it. So you can have somebody that's a money guy that's not going to be involved in the active day-to-day management. You could set him up as a preferred share potentially, and all it's going to affect is your tax scheme. So, what about these other ones that are on the board? A limited liability partnership, like I mentioned before, removed that general partner from a partnership. Because a limited partnership still has the general partner, the other thing that makes a limited partnership and a limited liability partnership dangerous is they only exist so long as the partners want to be a part of the business. So that issue that I talked about beforehand, why a partnership is a little bit dangerous. Say you have 5 guys. One of the guys gets a little bit disillusioned with the business. He realizes he's not making as much money as he used to, so he wants to go for greener pastures. If he leaves, it causes what's called a dissolution of the business. The partnership is gone. The other partners have to do something affirmatively in order to continue the business. So if a partner leaves a partnership, it's done. All the assets are divided up, all the liabilities are divided up, and everybody takes their toys and goes home. If the company doesn't have the assets, if it has more liabilities than assets, then when that partner leaves, then there could be some potential problems with a partner leaving. There's not enough assets to go around. There's not enough we've got too many liabilities. This creates a lot of problems. I am personally involved in several business disputes where a partner has left and there's been more assets than liabilities than assets, and it gets ugly. We call them business divorces because they are divorces and they get ugly. So part of the reason that we have these is that part of the reason that we have limited liability companies is a limited liability company can exist in perpetuity. Just because a member leaves doesn't mean that the business closes down, doesn't mean that you have to divvy up all the assets. As a matter of fact, you can state it pretty clearly that if you ever leave this business, the value of the stock is worth $1. And that's perfectly reasonable. Like I mentioned, your best case scenario for a lot of these businesses is going to be an LLC. There gets to be a lot of flexibility. That's also the danger of an LLC. An LLC, because of its flexibility, a lot of folks do the bare minimum in order to maintain them. This creates a problem, especially when you have multiple owners. They don't know what to expect. They don't know what their options are. What happens if I leave? What if I want to sell the stock? What if I want to sell my membership interest, is what ownership in a LLC is called. How do I handle that? If it's not mapped out beforehand, there's default rules that are not fun. So typically the work in an LLC comes into the operating agreement, subsequent agreements between the parties, and making sure that that's hammered out. Because there's not default rules like there are within a corporation or in a partnership. So part of the benefit of an LLC is that it's pretty flexible. That's why I typically recommend it, because it can be made to fit any number of circumstances. As far as the other ones that we have up here, like I mentioned before, professional corporation is provided only to specific professionals, such as accountants, lawyers, medical professionals. Same thing with a professional limited liability company. Now, in the last few years, we've started to see a new type of business come about, 2 different types, a business trust and a serious limited liability company. Now, a business trust is we figured this worked great, taking a corporation, kind of merging some partnership assets into an LLC. So a business trust kind of came around with the same idea. Well, we've got these trusts that work great on a family scale. Let's try to port them over to a business concept. And I'll be honest with you, I have never seen a business trust. It's not very common. It's a relatively new concept that's been...
I've never heard of it.
Alabama amended the law in 2008 and brought in a business trust. It looks like a trust, it acts like a trust, but it can do business. And that's really the only difference.
The tax limits on trusts are a whole lot lower than they are on individuals and people too. So.
But there's a lot of legal requirements on the business trust as well. So
I mean, like it would be a negative. Like your tax threshold and your tax is a lot lower with it. I don't know if the business trust rolls into it, but a regular trust, like you said, a regular trust, any income on that hits tax rates really early.
Yeah.
And I don't know if it's the same thing.
Yeah, so I imagine there's probably some tax scheme that's probably pretty advantageous to look into a business trust. But the code's long. There's a lot of stuff you got to do in order to maintain it. And like I said, I've skimmed through the law on it, and I've never seen it. Series limited liability companies are a little bit more interesting. Like I've mentioned before, you can set up a corporate structure so that there are multiple layers. In the old limited partnerships, you set up a corporate entity to be your general partner. That was just a business owning another business. In modern times, we do it through multiple entities. We'll set up an LLC for different vertical layers of a business. We're going to make a holding company that owns different location, subsidiary working business. We might even divvy it up even so complex that we're going to have a holding company that owns different LLCs that operate different locations in different geographies. You can even have horizontal segmentation where you say, well, we're actually going to have an LLC that operates our labor, that is going to lease our employees to another company that is the operational company that's going to take liability from companies. You see this a lot in construction, a lot in service sector, where you're going to have lots of business, lots of people working in multiple locations, and you want to isolate a large liability. So if an employment liability is going to be big for you, you want to isolate that in one corporate entity. If you've got a potential liability like in a construction scenario. The problem with all of these, of course, is getting insurance. You've got multiple entities, and the insurance company is going to look for their ways to get as much money as possible, so they're going to treat every single entity as its own thing. So several states have started running out a series limited liability company. A series limited liability company allows you to do that segmentation, but it's within the umbrella of a single LLC. Pretty interesting concept. Like I mentioned, it's only been adopted in a few states. It's not going to happen in Alabama anytime soon. I think we missed our shot. Like I mentioned, we updated the code in 2008, and that was a monumental undertaking. So I don't think we're going to be seeing a series at any time soon. But it's available. There are several states that do it. So if you are looking for some internal segmentation, there are some states that provide for that. So at the end of the day, what's the best business model, and why would you choose a particular entity? Now, this big legal disclaimer on all of this is every single situation is different. These are generalities. But in most closely held companies, your best options are going to be a limited partnership or a limited liability company. Sole reason is you can disregard the entity for tax reasons. Whenever you're looking at forming an entity, there's always two considerations. Legally, how do I maintain it? How do I protect myself? Secondly, what's my tax going to look like? How do I protect myself as far as taxes are concerned? And these operate oftentimes independently. The reason an LLC is beneficial is it can opt to be any tax scheme. It can be an S Corp, it can be a C Corp, it can be a partnership or a disregarded entity. Pretty fantastic little scenario for it. Problem is that with that flexibility, a lot of folks paint themselves into a corner because you can't change your filing basis except for what, once every 60 months or so?
I don't remember. I don't know.
Yeah,
not very often.
I think it's 60 months, 5 years. So if you come out the gate and say, well, we're going to be a disregarded entity, and then you bring in a partner and say, okay, well, now we're going to file as a partnership, that's technically one move because you get one move after you've filed. But say you get 2 years down the line and we're like, well, we're both working essentially on salary, and S Corp would probably be our best scenario. You can't do that. You've already made your election. So you're going to be stuck into a partnership scenario for the next few years. So a limited liability partnership and a limited partnership also offer the same tax benefits. It's that they're treated as every single dollar is treated as its own it's income towards the individual and it's not taxed personally. But we've also talked about the problems with a partnership, that it can be dissolved at any moment by any partner. You can put some restrictions in there, but you can't do a whole lot to restrict somebody's leaving a partnership. But we also see the benefits of it. So why would we recommend anybody go into a corporation? Corporations are typically reserved for companies that are high growth, or a company that is ever looking to go public. LLCs, partnerships, cannot go public. They have to have issued stock in order to be traded on the stock exchange. And even though you might be able to do that internally in an LLC, it is not recognized by a stock exchange. So if you want to go public, you got to have a corporation. Also, if you're going to be doing a high growth business and you're looking for venture capital exterior funding, most exterior funding guys hate LLCs. They hate the flexibility because most people don't go through the trouble to make sure that it's built out and it's formalized in an operating agreement. The operating agreement is typically about 2 or 3 pages, and most finance guys don't want to come in on that. So if you're looking for potential financing, corporations are the best scenario. These other ones that are out there, they're glitter. Professional corporations, you get the benefit of putting a PC on the backside of your name. Doesn't matter. It's a marketing technique. Same thing with a professional limited liability company. They're basically the same thing. You just get to put a P in front of it. Business trust, like I talked about, there's probably a scheme that would make it advantageous, but I haven't found it yet. Series limited liability company. Sounds like a great concept, but it's limited in opportunity for which states have it. So, with that in mind, we'll open it up to questions.